Criminal defense attorney, Fort Lauderdale, the stages of a criminal case and defendants' rights. A criminal defense is a right that is extended to everyone by the United States Constitution. Individuals have the right to defend themselves in a court of law if they are charged with a criminal offense. There are many different elements and procedures that make up the basics of a criminal defense law and a criminal defense case. The stages of a criminal case. In each criminal case, there are stages within both the state and federal court systems. While some stages in criminal cases are longer than others, each defendant will progress through the following stages. Number 1, arrest. The beginning of a criminal case is arrest. Usually, a law enforcement officer will arrest individuals suspected of a crime or those who were witnessed committing a crime. Number 2, booking and bail. After someone is taken into custody, they will be processed, fingerprinted, and put into a holding cell until they post bail. Once they post bail, they can be released. Arraignment. Number 3. During the arraignment stage, the accused and his criminal defense attorney will make an appearance in court. The court then reads the charges that are being placed against the accused. After they hear the charges, they must enter a plea of either guilty or not guilty or no contest. Number 4, plea bargain. At this stage of a criminal case, defendants may plead out their case so that they may receive a lesser or reduced sentence. The judge assigned to the case will have to approve the reduced sentence. Number 5, preliminary hearing. The preliminary hearings are a series of hearings that are held to discover whether there is enough evidence to go forward with a trial. The specific evidence against a defendant will be presented during these hearings. Not all cases will have a preliminary hearing. Some cases may move ahead to pretrial motions or straight to the trial. Number 6, pretrial motions. During pretrial motions, issues are resolved between the prosecution and the criminal defense attorney that may not have been presented at the preliminary hearings. Number 7, trial. During the trial stage of a case, plaintiffs must provide substantial evidence to the court that the defendant committed the crime in question. There are many stages of a trial, such as jury selection, opening statements by the prosecution and the defense, witness testimony, cross-examination, closing arguments by the prosecution and the defense, jury deliberation, and the verdict. Sentencing. When a person is found guilty during the trial phase, they will then be sentenced for the crime. Appeals. After the trial and the sentencing stage, an individual is allowed to file a petition for an appeal. The petition activates a review of the trial. Sometimes this may be because new evidence is surfaced. An appeal may result in a reduced sentence or the verdict may be overturned by the court. Regardless of the allegation, or wherever you may find yourself in the criminal justice process, Fort Lauderdale criminal defense attorney Robert Maylove can provide you with the legal help you need. For more than 24 years, Robert Maylove has been protecting the legal rights of those in South Florida. He understands the impact a criminal charge can have on someone's life and will aggressively fight for you to ensure that your rights are being respected. Get help now. Call 954-861-0384. 954-861-0384.